The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised.
Why do we have to, every time Rachel says something, you're just like, oh, you're not listening. It's just like, I don't get it. She is listening. She's listening to every word you say. And she's presenting something, and then you come back and shake your head and sigh.
Okay. Anyway.
Submit to an interview.
Wow. Stop. Well, if you let me. We're moving on to the next question. We're not gonna get very far with that. So
they can prove that this is not the first time she's done it. But okay. Even if you disagree with me,
I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd. Okay. All right. We're moving on to the next question.
What lawyer ever says that?
Well, yeah. You're welcome that I gave you that's such an easy way to roast me.
You know it's a possibility you might not win something. We're talking about the appeal.
There's no chance you lost this appeal.
Yeah.
You will have this.
Rachel, here, can I offer you like a cookie or something? What do you want me to say? What do you want me to say?
Not that. In our case, we like our case.
I shouldn't have said that. Can we move on? Okay.
Yeah. Well, pull it up. These statutes were invoked.
Yeah. Okay. Hang on. You're getting. Okay.
But show me a case that says that, because your cases don't. I've read them all now. Just give me a quote from Holgate. Just give me a quote from Holgate.
Can you hang on? Can you hang on for just a second here? Okay. Lord. Okay. You are pretending. Wait. If you want me to stay on this, you need to let me have fair opportunity to answer, okay?
David, of 58 minutes, you probably talked for 42 of them. I mean, come on, man.
Okay, guys.
Hold on.
Let me...
I got the
Rachel.
case there.
Oh,
There's
God.
only the Rule 11. Hold on. There's other authority. What was at issue in that case?
We got to move on. We got to move on from that.
Is the whole point. Try to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, Steve, can we move on? Because we're not going to get...
And then you come back and shake your head and sigh.
I know,
He
but...
don't have any authority to infringe his copy or whatever, that I interfered with his...
But way before my time. Way before I was there.
Way before you there. Where are these children?
Okay, you ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay.
She's still 6 months pregnant. Can I show my belly? How would she have a belly in November if she miscarried in July or August?
Look.
It's still not appropriate for her to include that finding of fact. Where are the people? There were reasons that her findings would have been inadmissible.
My Lord. Steve. Oh, my God.
And then Rachel gets 5 to 10 seconds before you sigh.
Read the emails with Clayton, the emails with Greg, the text messages with Mike. 5 that it is, but something that purports to be.
Whatever.
If you would have won, obviously, if you would have won, you would have gloated too.
Here, sign something saying that you raped me, that Laura was pregnant. I don't know what that would be. I mean, she's been running around subpoenaing things, apparently.
Welcome back, ladies and gentlemen, boys and girls, babies and gentlethems, all other assorted beasts, to your favorite cubbyhole on the internet. And yes, in another blazing ray of justice sunshine, we have breaking news. There is breaking news. Breaking news almost live from the cubbyhole. Or whenever I get this edited and posted. So it'll be less than live. It'll be tape delay, whatever that is. This is the news we've all been waiting for from the Arizona Court of Appeals. And let's get right into it. I'm not going to bury the lead. I'm not going to keep you hanging on a stick for an hour and a half, because that would just be unfair. It would be unfair because justice should never be delayed. We like swift justice. We like swift, lawful, active, energetic justice. It's wonderful. It's wonderful because this is our system. This is our system at work, and this is our system working the right way. And that gives me hope. And then in spite of this crazy world, because some of the rest of this crazy world, legally speaking, is a little bit crazier, and trying to break the law and trying to do so with court's blessings. But lest I get political yet again. Oh, shame on me. Let's not delay. Make haste make haste to the good news. Pursuant to motion for reconsideration and response to appellate's motion for reconsideration, it is ordered that the motion for reconsideration filed by Dingus the Douche Canoe on behalf of his client Laura Owens.
The fucking douche canoe.
Or should we say...
My name is David Gingras, barely a lawyer, hanging in there. Joining me today is the pregnancy faker extraordinaire, Laura Owens.
In behalf of pregnancy faker extraordinaire Laura Owens, the motion for reconsideration is denied. That's correct, ladies and gentlemen, on this breaking news. The motion for reconsideration is denied. And Judges Sklar and Vasquez concurred, dated April 30th, 2025, with Peter J. Eckerstrom, if I'm reading that correctly, the presiding judge. So you've heard it here. Certainly not first. I think others yet again have beat me to the punch, but that's the way it goes because, well, I get to things when I can. Sometimes that's not timely enough for the internet, but it is what it is. But we thank you all for coming nonetheless, because we all like to talk about things that are important to us. And justice and due process in this day and age and in this time and place should be important to everybody. It certainly is to me. And we like to talk about things that are in our sphere of understanding as best as we can. And this is one of those things. The cases where people use the system to scam and to try and abuse people with their false narratives, their facts, their lies, their whatever sort of potentially criminal behavior they're engaging in to try and pull fast one over not only the courts, but the entire world. We should be standing up against that. And we should be calling it out, because freedom, ladies and gentlemen, and all other sordid beasts, is not free. It comes through fought battles, not just in the court system, but early in our history, it came through loss of life and for fighting for the right thing and for justice. Justice and freedom have to be worked on. We can't just lay around, because if we do, we'll lose those systems of freedom and justice. And it's nice to see that the Arizona Court of Appeals got this one right yet again and denied this smoldering turd of a motion for reconsideration. Now, as Dingus the Douche Canoe has threatened,
The fucking douche canoe.
it's likely he will try to file further appeal in the Supreme Court. The Arizona Supreme Court will be the next stop, if memory serves correctly. I think this might be the end of the line for pregnancy faker Laura Owens. But so far, Dingus the Douche Canoe has yet to make any sort of interesting, compelling legal argument that's worthy of their time nor interest. So I suspect this is the last railroad tie, the last spike in the railroad, the final spike, the barricades and the flashing lights saying no further. And then what will be the next thing for Laura Owens? We don't know. And frankly, it's not our problem. But she certainly can't help but entering the public sphere when these things start to trickle into the court system and publishing her own smoldering dung heap of nasty used toilet paper called Medium. Oh, we have that. Yes, we do. We have that here somewhere. Ah, there it is. There it is. The court ordered him not to talk about me. He responded by launching a smear campaign. Well, no, that's not what courts do in orders of protection. They're not supposed to talk to you, and they're not supposed to engage third parties to talk to you. But no one is prevented from their First Amendment rights, freedom of speech, unless compelled in certain ways for courts to do so. This is not one of those cases. Orders of protection don't usually exclude First Amendment protections. Now, one has to be careful not to cross lines, because the court does usually have some stipulations on what one can and cannot do in regards to referencing someone with an order of protection. But those are on a case-by-case basis. And as far as I'm aware in this case, no such stipulations, other than out of the goodness of his heart, did Clayton talk about her. And it's certainly not within the court's purview to restrict the rest of the public free world from discussing this very public case that, if it had not been for a public figure like Clayton Echard, we may not have known about. It may have stayed a very quiet, private matter. But Clayton had the means and the wherewithal and the ability to make this a public case so that other people would not be wronged by this woman. They would not be taken advantage of by this woman, and they wouldn't be extorted into a relationship and then threatened and not being coerced by her vexatious litigation. The future should thank Clayton Echard to putting himself through all of this mess that Laura Owens began by filing a paternity petition for babies that didn't exist. And that was determined as a matter of law in a court of law, a family court as a matter of fact, that she was not in fact pregnant, and she engaged in other misconduct that is being reviewed by Rachel Mitchell of Maricopa County for criminal consideration. And again, we hope that criminal consideration will be considered, because it seems, as many have pointed out, myself included, this will not stop Laura Owens from engaging in this conduct. This is a pattern of behavior. It's a pattern of behavior that has been going on for quite some time, many, many years, and it will likely continue if some other system or institution doesn't intervene to stop it from happening. And there's no reason that other men should have to be subjected to the nonsense and the vexatious litigation that this woman engages in anytime she gets rejected or turned down, or people just simply don't want to believe her bullshit. Because that's the narrative that she has been pushing. It's been bullshit. It has been smear campaigns that she's tried to engage in. And as I said in a previous episode, it's my opinion that they have engaged in their course of conduct in defamation and tortious interference with Clayton Echard. That's my opinion. That's my point of view because of what they've said, making criminal allegations that were unfounded and non-factual. I think she will continue. I think she will continue this abhorrent and unhealthy pattern of behavior until something stops that. The public doesn't have much recourse other than to expose people like this and patterns of behavior of this manner. We have every right to do so, not only given our freedom of speech, but using all of the public court records and public court proceedings that we have been fortunate enough to see. Because in our system, courts and proceedings are not private affairs. Courts are courts of public record for a reason. Because justice cannot serve itself, shrouded in privacy and potential to be abused. Our system will not stand if it gets abused. If people don't follow the law, if things aren't available to the public for scrutiny, and should there be misconduct or wrongdoings within that system, the appropriate and legal actions be taken. That's why we have a transparent system. That's why it's a public system. It is to prevent our system of justice and our system of jurisprudence from collapsing. And that's why we talk about these things. It is within my own value system to right wrongs and to make certain that justice is followed. It's just the moral and ethical thing to do things in the right. Now, we can't always be right. We're human beings, we're flawed, we make mistakes. But where we can see that injustice and wrong things are done, it is our duty as citizens of this country and to protect the freedoms that we enjoy, not only within the sense of being a free nation, but within the justice system, to talk about these things. This is why the freedom to assemble and the freedom to protest are integral, important things in our Constitution. This is why free speech is an amendment. It's the First Amendment. We can't right wrongs if we are prevented from discussing them, if we are penalized, if we are punished, if we are litigated for exposing poor behaviors, for exposing bad conduct, and conduct that should be considered and scrutinized legally in a court of laws. That is the system. That is the mechanism by which we right wrongs in this country, through the legal system and the court system. And this is why it's so important to have an attorney who's competent. And this is why I think Dingus the douche canoe,
the fucking douche canoe,
has not done his client any favors. As with many, I don't have a high opinion of him based on his conduct and based on his, in my opinion, his lack of professional conduct. And certainly I have questions about his ethics. And certainly I have questions about his past that precipitate the behavior that he is engaged in that we have seen throughout this case. There's so many things. There's so many things. And as I've kind of come to the realization more recently, Who we are today is a culmination of our past, and it's also a culmination of our past traumas. They all have influence and bearing on the person we are. We all have them, and it's how we heal from them, process them, manage them, get over them, move on, grow, learn, all those things. All those things a good therapist might tell you need to do in order to progress and move beyond what could be lifelong stumbling blocks. And Laura Owens' conduct is certainly going to be a lifelong stumbling block. If something doesn't stop this cyclical pattern of behavior she's engaged in, or if some other system doesn't prevent her from doing so. There's many means that could go about that, and the criminal system may be part of that. We're not sure yet. Rachel Mitchell may still bring charges. It's hard to say. They may not. They may have more important things to do with bigger problems than a pregnancy faker extraordinaire. But we would hope that something may be done, because it's clear that a number of things were violated in the case and the conduct, certainly throughout the course of this thing. Since the beginning of the paternity filing, and certainly in my view, and I think in the view of most of any great interest, certainly anyone who's paid attention to this case, anyone who's watched any of the other proceedings involving Laura Owens and the paternity actions she's engaged in, and also the orders of protection she's engaged in, where she, in the view of myself included, has pulled the wool over the court's eyes to engage what we believe are fraudulent orders of protection against various men. And those protections were sought after just to be punitive and to be malicious. And it was her hope to silence them, to prevent them from discussing how they were conned by her in a relationship scandal and pregnancy scams. A court of law found these things. An appeals court has upheld the findings of the trial court. So unless the world burns, I think it's safe to say this is a concluded matter. But as her attorney, Dingus the Douche Canoe,
Fucking douche canoe.
has threatened he will march this as far as he can, and he thinks he's going to SCOTUS, the Supreme Court of the United States. I don't believe he's going to make it that far. If he does happen to make it into the Arizona Supreme Court, I would be surprised. But it would certainly give us even more to talk about and to laugh about in his laughable filings. Because the structure, the content, and the substance of his filings thus far has been laughable. It certainly hasn't been, to quote the Arizona Court of Appeals, based in law or fact. So what else could they be? One would think if they are based in law and fact, something would be made of them, but they weren't. Just as Laura's Medium articles are used toilet paper, so are Dingus the Douche Canoe's legal filings, in the view of myself. I'm allowed to have that view. It's my opinion. I can have it. But let's move on. That's enough discussion about Medium. Of course, others have read the filing by Clayton Echard, written presumably by Marcus Riesinger of Woodnick Law, their response to Laura Owens. Schnitzel Ninja read through this. I don't feel the need to read through all the words. They're great. It's very thorough. It reiterates how poorly written and what a poor attorney Dingus the Douche Canoe is at trying to make any legal arguments. And the conclusion was quite specific. Of course, this is all kinds of things. The conclusion, the Court of Appeals correctly affirmed the trial court's ruling. Clayton requests the court deny the motion for reconsideration, grant leave for Clayton to file a supplemental application for attorney's fees. Guess what, folks? That means that $150,000 fee awarding by Judge Julie Mata in the trial has just increased due to this rather shitty filing by Dingus the Douche Canoe on behalf of pregnancy faker extraordinaire Laura Owens. Maybe I can learn how to say that faster. I could make it sort of a thing. The court should also note that Laura did not timely file an objection to the application for attorney fees and costs filed in this appeal. That number is going to increase. Would anyone like to wager bets how much larger 150 will go? 160, 170, 180? Will it crest $200,000? One wonders. We may see, in which case we may do a little blurb on that, because it's interesting stuff how these things increase incrementally, and Clayton will be entitled to every penny of it. But we know we know that almost with certainty, she will find a way to attempt to default. That's my belief. Her attorney has already signaled that she may do that. They did that in their little podcast, if you want to call it a podcast. And he sort of intimated and reiterated that in his so-called debate. His ass spanking by Rachel Juarez. And that, on Reality Steve, he intimated that Laura may file bankruptcy. And then he sort of suggested, but she doesn't want to. I suspect she will. That's my belief. It's my opinion. I'm entitled to that. And then it'll follow very much a similar trajectory of the Jen Camp against John Dehlin of Mormon Stories case. Hopefully I don't need to reiterate that because I seem to compare them quite a bit. We may just make a little footnote. This is my footnote. Footnote number 1. That case was about Jen Camp defaming John Dehlin, which the court found to be true. And the court awarded fees for defamation to the tune of, I think it was $1.2 million. It was a lot of money. And Jen Camp filed for bankruptcy to try and avoid the judgments, and she did other nefarious things to escape judgment and try and make herself, quote-unquote, judgment-proof. Again, it's my belief Laura Owens will try and escape payment at all, as Dingus the Douche Canoe implied that he doesn't want her to pay a dime to Clayton Echard, or something to that effect. That's not a direct quote, but that's the gist. I think they will try that. I think they'll try a little scheme to try and avoid paying Clayton hundreds of thousands of dollars, I think. And if this goes any further to the Arizona Supreme Court, that number will only increase, as we have said before. At least I think I've said that before. Pretty sure. It's ridiculous. This is where people need to be considered vexatious litigants. When appeals are not based on law or fact, it's time to shut them off. It's time for the court to rule that these are vexatious litigants and that they're abusing the process. Forum shopping is a sort of a means to an end here. That seems to be what they hope. We don't like the result of the trial court. Well, it's their right to appeal it. Well, we don't like the result of the appeals court, even though everything in our argument wasn't based in law or fact. Well, we'll just keep trying to forum shop it around, hoping we get a judgment we do like. I think that's what it's called, right? Forum shopping? I think. I presume. I could be wrong, but I think I'm right about that. They didn't shop it around other courts. It's hard to do that these days. It's sort of like forum shopping healthcare. It's pretty tough. You know, there's reasons we have records and things electronically are easier found than piles of paper anymore. So it's difficult to do that. Although that certainly didn't stop Laura Owens from falsifying and manufacturing and faking and fraudulently creating medical records. And certainly stealing those medical records of other people, like sonograms of vanishing twins of other people almost a decade ago that she used. Oh, let's not rehash old evidence, shall we? I'm not going to talk more about the response by Clayton Echard because it was wonderful. Schnitzel did a great job, very professional as always, reading through that. What did intrigue me, not going back to the Medium article, the smoldering pile of used toilet paper, what did intrigue me in all of this garbage that she wrote, most of which out of context. I did spend some time reviewing some of the old orders of protection hearings with Magistrate John Duty. How that man, he might be a little foolish if this has made news locally. Maybe he feels a little foolish having bought into this woman's false claims of pregnancy. Don't know. I doubt he'll make any public statements having heard any of these things regarding Laura Owens, and certainly it's his prerogative. But what intrigued me was that Laura had filed. Well, it wasn't a filing. Where the hell is it? She had written a request for or waiver of victims' rights form. And Laura Knighty talked about this on her channel. She was with Bruce the Moose of Oregon, the dynamic duo of fun and fact. They work well together. It's not great resolution. I'm sorry about that. But this piece of paper that somehow Laura has her name attached to intrigued me. The victim request for or waiver of pre-conviction and or pre-adjudication rights. I had to do a little research about this because this is not your standard police incident report form. This is not your regular case filing. This is not a regular police filing, I don't think. As you can see, there's no number attached to it in the top right. There's no case number, just a bunch of X's. This is something handed out to possible victims, and it really says nothing of great substance. It gives the reporting agency, Scottdale's Police Department, obviously, despite it saying, press hard, you are making 5 copies, this is not handwritten. This was electronically written. This is electronic type on this form, which intrigued me. So where did this form come from? And it made me wonder, was this form a fabrication? It may not be. I don't know. But we do know that Laura is capable of manufacturing fake evidence, of creating fake forms. She certainly faked medical records. She produced medical records that were not factual. They were certainly not real. And they were, in many cases, well, certainly some of the cases with the HCG tests, I can't say it, with the HCG tests, where she falsified the information on those documents. So it's not beyond her to make up forms. That's not an unreasonable assumption that a logical, reasonable person might conclude, given knowing her case history and her propensity to manufacture records to support a narrative she's trying to sell. So I did do a little research. And this is a legitimate form that does exist in Arizona. Evidently, some municipalities have it available electronically. I have not found any yet. I'm still on the search to see if one may have found this form electronically and filled it in themselves. Is it a real form? We'll find out. But there's nothing of great value in this. There's nothing alleging a crime. It's just a victim request. Presumably this does go to some jurisdiction, probably some court somewhere. But the question is what for? The identifying information, Scottdale PD, there are some things redacted. I don't know why the phone number of Scottdale PD is redacted. It may not be. I think that's public information. The reporting officer would certainly be public information at some point, in spite of this being redacted, as would be citation numbers and locations. There are public records for a reason, and this is probably going to be in the public soon enough. I'll bet someone has FOIA'd it already. Not me, but I'll bet someone has. And when we find it, we'll talk about it. There has to be an impetus for this form. The arrest detention status, the suspect, this is presuming Clayton Echard, I believe, is not in custody. Let's see, it's hard to read that. No, the suspect is known. The suspect is adult. There's no other information. There's no other information in this box at all. The victim or victim's lawful representative. The victim is typed as Laura Owens. It has some of her information. We don't care about that. There's no lawful representative on this form. So her current attorney is not listed. It gives little more than her personal information, address, contact information, so forth. And is the little box that's checked, I request my rights. So this is a request of rights as a victim. And what does that mean exactly? Let's talk about that, shall we? This comes from the Attorney General of Arizona, Chris Mays. The victim's rights request and waiver forms. Beginning in September 1, 1996, Arizona victims' rights statutes require law enforcement agencies to provide a multi-copy form to victims upon initial request. The multi-copy form, developed and distributed by the Attorney General's Office, the AGO, is used by a majority of law enforcement agencies statewide. The Victims' Rights Request Waiver, RW form, contains information that all victims of crime are entitled to by law, regardless of their status of their case. The AGO annually maintains and provides electronic updated versions of this form at no cost to each agency, as long as victims' rights laws mandate the form and require that the AG provides statewide implementation assistance. So somewhere, which is missing from the shitstorm Medium article posted by Laura Owens, is any sort of cause of action that would request one to have their rights. There is no pending criminal case that we're aware of against Clayton Echard, although she probably wishes there was. So is this yet another attempt to engage in harassment via the court system? We don't know of any cases pending beyond this one with Clayton Echard. If anything comes to light, we'll discuss it. But it makes one wonder, what is the purpose? Because in her Medium article, and I'll click back over there, where is that? That was towards the end. She made a statement. She said, "When I finally contacted the Scottdale Police Department on April 21, 2025 to report Echard's repeated and flagrant violations of the protective order, which is still in effect today, a response arrived via email. There's probable cause that a crime has been committed against you." A quote without evidence is one that we need to question. There's no context. There is no police report that she has submitted that she claims where there's been violations. And to the best of our knowledge, again, there's nothing restricting him discussing this case, which is a very public case. And I think Clayton has been extraordinarily kind in not discussing it and hoping that no one engages in inappropriate conduct in discussing it. Now, we've made lots of comments. We've made lots of criticisms, and that's our right to do so. But one wonders what she's trying to do with this move, other than to harass Clayton Echard yet again. But we need to call these things out. And we wonder, what rights is she seeking, other than she's attempting to intimate crimes that don't exist? And as I've suggested before, in order for this to stop, more needs to be filed against her. It needs to be filed through criminal avenues. Because she's not going to get the message. This is going to go on until she believes she has won the fight. But the fight is not on her side. She's not winning. She has lost continually since the beginning of the paternity action. And she'll continue losing because the facts, the truth, are not on her side. She wants us to believe otherwise because she's manufacturing all sorts of things. All sorts of falsehoods, all sorts of narratives, in an attempt to convince us and gaslight us into believing her. But it won't happen. It's too late for that. And where there's truth, the lies cannot stand up. They won't hold any water. There's too many holes in them. And that's what the trial court proved. And that's what this case will continue to prove for the time being. There's not much for this to go. Not at all. We're at the end of the line. This is the last stop. Unless the Supreme Court of Arizona hears this case, which is highly doubtful because they prefer to only engage in issues of law that need to be considered. And it tends to be things that involve legislative process. Is that the right phrase? I don't know. I'm not a lawyer. I've said that so many times it's not even funny. But we do understand how some of these things work. And where there's violations of constitutions and other law that may be missed by lower courts, that's the role of the Supreme Court. This is not a due process violation. This is a woman engaging in vexatious litigation because she's not getting her way. And it's time for the state of Arizona to stop it. She's wasting court resources. She's wasting resources of the opposing side. It's time for this to end. Oh, Rachel Mitchell, you're our only hope. Where are you? Well, she may not be the only hope. The more Laura engages in inappropriate conduct, and the more she continues in what may be criminal conduct, if that's found to be the case in a court, she's only making this worse for herself. And her lawyer is not helping her. And we've said that before. This is sad. It's sad that things have to keep going because we just can't accept the truth. And we've talked about how Laura just seems to not get it. And we've talked about some of the theories for why she may not get it. I don't wish repeating those. You can go back and listen to other episodes. That'd be lovely. We'd love to get the watch hours up. Please and thank you. If we wish this thing to grow, and if it grows, that's great. If not, I'm happy talking into the void a little bit. Well, it's not a void. There's almost 80 people that are subscribers. That's more than zero. Well, for that, we are grateful. To each one of you who listen to these ramblings that go on for minutes on end, bless your hearts. In the nice way, not in the nasty Southern way. Bless you for your indulgence, and also in for your fighting for the cause of good, right, moral, and just things. And rather than drone on more about things Laura talks about, or the filings, or where things stand, let us rejoice. Let us be glad. Let us be grateful. Let us rejoicify that the appellate court denied the motion for reconsideration. And I think that's enough silliness for today. Yes. Yes, indeed. But they may endear us. They may endear us with more silliness and more buffoonery, trying to carry this higher up to the courts. To the higher courts, at least. Whichever courts. What's next? The court of silliness? Where vexatious litigation that's not based on law or fact should go? Maybe we need an intermediary court. I'm not sure. But we'll see. We'll see what brings us next in the case of pregnancy faker extraordinaire, pregnancy scammer, pregnancy fill in the blank, fake pregnancy perpetuator. Oh, there's so many ways to go with that. Yes. Okay. I think we're fulfilled now. We've hit the breaking news. We've hit on some of the recent postings. That's enough, don't you think? I think so. Good night, everybody.